Well, thank you, everyone. We're going to move on to our next panel. I'm glad there's so many good discussions happening. And our next panel is unique in the sense that we have people who will be discussing federal oversight of forensics. So we're very fortunate to have a diverse group of folks here talking about how forensics are changing on the national level and kind of federal involvement as well. First, we have on the far end Mr. Chris Fabricant. He's the Director of Strategic Litigation at the Innocence Project. Before joining the Innocence Project, he was a clinical professor at Pace Law School, where he directed the Criminal Justice Clinic. He has an extensive background in criminal justice work. And at the Innocence Project, Mr. Fabricant has focused on bite mark cases. He's assisted people on death row, particularly in Mississippi. I know he has some very interesting bite mark cases in Mississippi right now that hopefully are going to be making national law for all of us. And he's also closely involved in the review of thousands of FBI cases for hair microscopy testimony errors. We've heard that review brought up a few times today, so we're fortunate to have Mr. Fabricant here to discuss that. Next we have Professor David Moran. Originally trained as a chemist, Professor Moran later became... Oh my gosh. That's my bad. Physicist, thank you. Professor Moran later became an attorney. He now directs the Michigan Innocence Project, an incredibly successful project. Sadly, he's on his own because his co-director of the project, Bridget McCormick, was elected to the Michigan Supreme Court. They were truly a power team. Professor Moran also serves on the Legal Resources Committee for OSAC. He's an outspoken advocate, particularly on issues of shaken baby syndrome and arson cases. Next, we have Dr. Glenn Jackson, who's an associate professor here in our Forensic and Investigative Sciences department at WVU. He's also a leader in creating a PhD program here at WVU in the forensics department. That is set to launch, I believe, next year. Am I right?
This fall.
This fall. And is going to be one of the few PhD programs in this area and is so needed. So I applaud his efforts on that front. Dr. Jackson also serves on the Controlled Substances SAC within the OSAC and is responsible for defining national standards for forensic chemical analyses through that SAC. Then finally, we have Dr. Suzanne Bell. She's a chemistry professor and also a faculty member at the Forensic and Investigative Sciences Department here at WVU. And Dr. Bell serves on the National Commission on Forensic Science. She was a key force, along with Dr. Jackson, in establishing our Forensic Justice LLM program here at the law school, which is a joint endeavor between the Forensics Department and the law school. She's also written a well-known dictionary on forensic science. So please join me in welcoming them.
Dr. Bell.
Thank you. And how do we bring this to the... There you, I knew he'd be here. Thank you, and thank you for the opportunity to speak to you this morning. I'll give you some brief remarks about the National Commission on Forensic Science. I've been on it from the inception, and I think there's a lot of exciting stuff going on there. And we'll talk just briefly about it, show you the website where you can look at some of the work products that are going on. Since I'm in a room full of lawyers, there you go. Okay. I'm clear, okay? This is me speaking. I'm not on behalf of anybody but Suzanne. So, okay, there we go. They make me put that in. This is the National Commission. It was established 2 or 3 years ago now, and it really was an outgrowth of the National Academy Report, and it is a federal advisory board. So strictly speaking, the only folks that we can make recommendation to is the Deputy Attorney General, She has been at our meetings, which was great. I mean, we were very glad to see her when she took over about a year ago. And the co-chair is Dr. Willie May, who's a chemist at NIST. And we'll talk a little bit more about NIST's role in this. But NIST is the National Institutes of Standards and Technology, who are starting to become a very important scientific force in forensic science, in addition to the Department of Justice and NIJ. The co-chairs and vice chairs, John Butler, who some of you may know through his work with DNA. He's probably one of the best DNA people alive today and has done a lot of work with DNA mixtures. He's at NIST. And also Nelson Santos, who is up in very high in rank. I don't know his position now, but he's within Drug Enforcement Agency. So that's the commission. There's our website there. I won't go through it, but there is a place on the left-hand side to look at work products, and I'll point you to some of those you might want to look. There's a bunch open for public comment right now, and we welcome public comment. We need public comment. We take it very seriously. So please take a look at it. And it's a relatively short period of time for public comment, and our next meeting is in 3 weeks. So we'll be meeting to discuss these documents. The members, we have 40 commissioners, 8 ex officio, who are federal laboratory representatives who don't vote per se on these decisions, but are part of it. And then we have an enormous number, I don't know what the number is now, that people that are affiliated with our subcommittees. So I'm a co-chair of the Scientific Inquiry and Research Subcommittee, and our subcommittee has, currently we have about 8 people that are not on the commission that are working with us on the subcommittee, and some of the other subcommittees have many more. So we have at our disposal a really wide array of folks. We also, in our particular subcommittee, have 2 members of the Innocence Project. Peter Newfield is on it, as well as Sarah Chu. So it's a very diverse group of folks, and the meetings are very interesting and exciting in some ways, but we are making progress. I'm very, very happy about the progress that the group is making. There are subcommittees currently. We just added digital evidence recently, so they are now included. And a number of folks belong on both committees, and I'm only on the Scientific Inquiry and Research Subcommittee. And we have some of the most interesting work is coming out of human factors. And the Interim Solutions Committee is lasting a little bit longer than we anticipated, but they are making some big inroads on things like wording and reporting and things like that. So I think they're about done, and then they will merge back into the committees that exist now. So those are the existing committees. Many of the names that you've heard this morning, Judge Hervey is on this commission. She works a lot on the training. We have several members of the Innocence Project. We have Dr. James Gates, who's a very famous physicist from the University of Maryland. So we have quite a diverse group of people on here. And then 57 non-commissioners and counting that contribute. So they'll come to the subcommittee meetings, but not necessarily stay for the full commission meeting. The full commission meetings are open. This is all because of the federal oversight. It's open. You can look at all this work that's going on. So that's available for you on that website. I won't go through these, but these are examples of our work products. And really what we can do are write different kinds of documents. We can write views documents in which the commission expresses an opinion. But remember, the only people we can really talk to directly the only person we can talk to and make recommendations to directly is the Deputy Attorney General. And she, in turn, has control over the federal laboratories. So there is no National Supervisory Board for forensic agencies. So we are within the charter, that's what we can do, but we hope that what we recommend and our views documents carry some weight in the larger community. And we are represented by a lot of state and local labs, and we also have police agencies represented, so it's a good group and mix. These are some of the ones that have come out recently. We work on things like supportive scientific literature, although we have a document I'll talk about in a moment that's open for public comment right now. So you can look at these, you can see what's been done and what's coming out of it, and there is movement on many of these. The Deputy Attorney General has reported back what she is recommending and what's happening on these things. Some of the topics under development are probabilistic statements, we're surveying forensic science service providers because we realize we don't really have a good handle on how many people out there are really doing forensic science work. I mean, we think of forensic science as being done in laboratories, the state and local lab, but there's a lot of other people that are involved in forensic science service providers. There's police units, police laboratories that do crime scene response, so we need a handle on who these people are and where we can find them and how we can reach out to them. There are 2 documents that the Scientific Inquiry and Research Committee has put up for comment as of yesterday, and it really feeds in very nicely to this discussion that I've been hearing this morning. One of the problems, as you all know, and scientists know this as well as the forensic practitioners, is we really expect an awful lot of the judiciary. I mean, we expect them to judge science, and that's like putting me on the appellate court and saying, knock yourself out, and then getting angry at me when I make a mistake. I mean, we're really asking people to make judgments on things that is not necessarily their forte. And this is widely recognized as one of the it's a big problem in forensic science. So we have put up 2 documents for review. One's a views document where we in essence say, NIST, we want you to become the gatekeeper. And so that at least judges have some document from a scientific organization that's renowned for over 100 years as reliable. They understand science, and they can review the validity of the science underlying these decisions and then hand that to the judiciary. Because what we find is there's a lot of good research in the literature, but getting it through the doors of the forensic laboratory is very difficult. And our cultures don't mix. Science invites change. I mean, if I was to hold this pen out and it didn't fall and it went straight up, the scientists in this room would think this is the coolest thing ever. But the law is, if you think about it, is we worry about that, because if we say, well, this is a better way of doing it, then the response is, well, that means what you did in the past was wrong. And so that culture it's a very difficult thing to break through. So our subcommittee works in particular to try to overcome that and to provide tools to the judiciary and lawyers in general that helps them evaluate scientists if they're not scientists. So that document is up, and we've given an opinion document. This is not a final commission product yet. It's out for its initial public comment, where we really have asked NIST to help in this area, because we, as scientists, NIST is very well respected. And they are a scientific group, not necessarily associated with law enforcement in that sense, although they've been doing forensic science for a long time. And John Butler is a good example of that. The other one are specific recommendations for how to implement that, and what do we really mean, and how are we working on that. And it's a good example the collaboration exists, because the group that worked on that included Peter Newfield and Sarah from the Innocence Project. So those documents are truly collaborative. So I guess I would mildly disagree with one of the earlier panelists about the National Commission. I take kind of the opposite view. I think it's this generation's best chance to make meaningful reform in forensic science. I mean, it is the platform that we have. So we are going to work very hard. But please, not just our documents, look at the other subcommittee documents. There's a lot of interesting stuff coming out, things like terminology, reasonable scientific certainty. What does that mean? Well, there are a lot of terms that shouldn't be used. And so we have to communicate that information. So the documents, although they are views and recommendations to the Attorney General, we hope that they have a much broader scope. And so please take a look at those documents, because all of you have a stake in that. And comment, because the comment period and the public comments we get are taken very seriously and discussed and debated. And, okay. What do you know? So this is a group of folks that are here. Because we're entwined with NIST, we work a lot with them. We can't talk directly to the OSACs, but the NIST is very involved in this. That's mostly a structural and procedural thing, but NIST is deeply involved. I'm on the SAC for gunshot residue as well. So these are not separate endeavors. They're very closely linked. Borders are crossed. And I guess I would close my remarks with cautious optimism about where we're going and the things that have been put in place to try to move forward on this. And again, get involved with things that are going on, because the national level trickles down if it's successful. So thank you.
All right, well, thank you very much for the opportunity to speak today. I will also start with the caveat that although I'm in the Department of Forensic and Investigative Science here at WVU, the opinions that I express today are those of my own and not of the department. I also serve on the NIST OSAC for seized drug analyses, and the opinions I express are mine and not those of the committee. And in fact, I'm one of 3 academicians on about a 20-member panel that's made up mostly of practitioners, and so in many respects, my opinions are likely to diverge from those of the committee. So I wanted to talk a little bit about the status of seized drug analyses, at least at the national level and the local level. I should also add that although I'm serving on the seized drug subcommittee, I'm generally I consider myself an expert on forensic chemistry, and that covers all aspects of ignitable liquid residue analyses. We do research in the area of ignitable liquid residues, chemical hair analyses, and things like this, trying to come up with more objective methods of analyzing evidence. So if we look at seized drug analyses, for example, and what the National Commission thought of this 6 or 7 years ago, GC mass spectrometry, which is the core technique, is kind of considered one of the gold standards, and I maybe as a bit of a joke, I'm going to tell you that I think it's a platinum standard in terms of forensic science, and I'll show you a little bit why I think we can do better than DNA. So GCMS was mentioned twice, and neither one of those was negative. So in all respects, seized drug analyses is not flawed, and so I may as well not talk anymore. But of course, that's kind of tongue-in-cheek. Of course, there's always room for improvement. However, for example, error was mentioned 99 times, and that doesn't include occurrences of error within terrorism. In terms of reporting error, Dr. Bell already mentioned NIST, and I thought I'd just show you one of the best examples of a description of error that I think I've ever seen. I just discovered this a few weeks ago. This was by a scientist called Charles Myers, and this was back in the 1920s. He was doing some research on trying to establish the specific heat of ammonia, and this was a very difficult experiment. It took him several years, several faculty, researchers at NIST. It used to be called the National Bureau of Standards, NBS, before it became NIST in 1969. And so they reported some error here. We think our reported value is good to 1 part in 10,000, which is pretty good. It is very important to give an estimate of the uncertainty of a result whenever we report a scientific result. And what's even better, though, is where they went. If by chance our value is shown to be an error by more than 1 part in 1,000, we are prepared to eat the apparatus and drink the ammonia. I think that would go over pretty well with the jury. I don't know. It's slammed dunk. All right. As I mentioned, I served on the NIST OSAC for seized drugs. We were called controlled substances, but the first thing we did was change our name for whatever reason. So we're down here. And there we are. We all look like this. This was at a meeting about 3 or 4 weeks ago in Leesburg, Virginia. And at present, we have one standard in the commission, and it's one that came out of our subgroup, and it's called the standard practice for the identification of seized drugs. And if you pay $39, you can go to ASTM and read it. Right? It turns out, actually, that last week, NIST came to an agreement with ASTM, and they're now going to provide up to 30,000 government agencies these forensic science standards for free for at least the next 2 years. So there is hope that... and I should add the caveat here that, although you pay that $39, if a government agency like a crime lab paid $79, maybe $75, they would have free access to all ASTM standards for the year. So it's not, I don't think, a terrible financial burden to expect an agency to pay $80 for a year to have free access to all these standards. But there we go. So let's look at this first standard. We're kind of obligated to go to SDOs, Standard Development Organizations, and they have to be accredited to be able to develop standards. And part of that process is to have committees with wide representation. They form consensus opinions. They write documents and agree on those. They put them out for public opinion. The public can comment. And then they have to address each one of those comments. So if there's 70,000 public comments, they have to address each and every one of them. And then they go through like an adjudication process, and then the report, it's kind of final document. And then they have to be reviewed every few years, maybe every 5 years, and they go through that whole process again. So this is just a general how SDOs work. This particular document has been, you can see this is a 2014 edition of this document. There was a 2009 version, maybe. And again, it's called the Standard Practice for Identification of Seized Drugs. It's 2 pages long. And when we sent it for approval as a recommendation to be on the registry of approved standards, we received 6 pages of feedback from the Legal Resource Committee, which was interesting. But of course, and so basically, what this was like, because it was the first standard that went through, it basically made us all. It was the first time we were really communicating, and it made us realize that basically we were coming at this thing from 2 totally different angles. On the Seized Drugs Subcommittee, we're really trying to help crime labs do their thing, right? We're trying to standardize and make uniform what crime labs do, how they collect, analyze, and interpret and report their measurements. And what the Legal Resource Committee is trying to do is help the legal system, right? How do you use evidence? How do you tell junk science from good science, right? And they're 2 totally different things. So the documents we write are for crime labs and for scientists, and the reviews we get are from the perspective of the legal system, which that's not the documents we're putting forward are not very useful. And I think it's very important now that NIST works together with us all to figure out exactly what it is, like who are we trying to help and how are we going to do it, because the way we're doing it, I think, is not very helpful. Right? And I guess we might hear more about that. In terms of what's in the document, what we basically say is that there are a plethora of analytical chemistry techniques you can apply to the analysis of seized drugs, and in a nutshell, if you use several of them in a certain way, that you will have effectively no uncertainty. Now, we don't say there is no uncertainty. We say the uncertainty is so small that it's effectively zero. It's practically zero, right? And I just wanted to talk a little bit about why we have that, why we say that, and why we think that. So let's look at, for example, DNA analyses. How do we analyze DNA? It's the gold standard, right? Well, we separate it using a separation technique, an analytical chemistry technique, and then we detect it using a fluorescence detector. And that fluorescence detector can tell blue from green, from orange, and from red. And so in terms of, if you were to compare DNA analyses to how we do drug analyses, you would say that there was a category B technique, which is pretty good at separating things, and a category C technique, a presumptive for fluorescence. And so this would be considered like one measurement, and for seized drugs, we would want you to do at least 3 measurements, right? So in terms of DNA analyses, yes, you've seen something separated, and you saw a signal, oh, I saw something blue, right? But then we'd have to do 2 more techniques in the drug world to be able to say with the degree of confidence that we do that it really is the thing that we say that it is. The way we do that is like this. We take a complex mixture, we inject it into an instrument, it separates each component as a function of time, and then at each one of those times we can click on the kind of detector response, and if we were in the DNA world, we would say, oh, I saw something orange or I saw something red, but here we can click on a peak, which is actually a compound that's eluting, and look at kind of a fragmentation pattern which tells us how that molecule is made up. It tells us the mass of the molecule and all the little parts of it. So it's like a chemical identity, kind of 2 in 1. Again, this is one analysis, and we would have to do 3 different methods of analysis in the drug world to identify a substance. So again, we kind of think of it as, I'm going to joke that it's a platinum standard, really. When NIST developed the software, this kind of library of database of compounds that we can send our spectra to see, what does it look like. They developed this through a DARPA grant for the federal government to detect chemical warfare agents. And so they ran 30,000 GC mass spectra data files through the system looking for chemical warfare agents, and they had 0 false positives. Just one example of the false positive rate for GC mass spec. And again, this would be one of 3 totally independent techniques we would use to identify a drug in an unknown. In terms of GC mass spec, is it valid in the scientific community? Well, there have been at least 5 Nobel Prizes given exclusively for these techniques independently, and this is independent of all the Nobel Prizes that have gone for techniques that are dependent on GC mass spec or mass spectrometry. 1911 was the discovery of mass spectrometry by J.J. Thomson. 1922 was the discovery of stable isotopes and the whole number rule. 1939 was the discovery of the calutron, or the development of it, which isolated heavy metals for the Cold War project for bombs. 1957 was the invention of gas chromatography. 1989 was the mathematical description of the quadrupole, which pretty much all crime labs use to analyze drugs. And finally, 2002 is the Nobel Prize for electrospray and MALDI. So rather important analytical pieces of equipment. And it's used in a variety of techniques outside of forensic science. It analyzes all the food we eat, all the cosmetics we put on us, everything around you that you touch. It monitors the air that we breathe. It monitors other planets. There's currently a GC mass spec on Mars, on the rover, looking for life on another planet. It's used for environmental analyses, whether that's in the air or liquids or solids. We have them in the North Pole, the South Pole. We analyze oil and gas. We have done since the 1940s using GC mass spec. We can analyze paints, polymers, and adhesives, fine chemicals, and you name it. It's accompanied every manned mission to outer space, well, inner space. Whereas we still have room for improvement in terms of putting hard numbers on the error that we have for trying to put a number on this infinitesimally small probability of a false positive in a drug analyses, we certainly there is some work we need to do to be able to come up with those numbers. But for sure, there's nothing wrong with the techniques. There's because humans use them, there are problems with the humans. And so most of the problems we're going to have in this world, at least in siege drug analyses, are going to be with the humans that analyze them, and how do we control the system and the organization and the management to be able to identify those. And of course, there's a few classic cases, one here in West Virginia, where you have a few rogue scientists, and you just need a system to be able to identify those. So I'll leave that there, and I'll be more than happy to, to participate in the discussion in a few moments. So thank you.
Nothing projected.
Oh, yeah, the mouse
You're
is...
on the second screen there.
Oh, there it is. All right.
I am extremely low-tech. I will not have a PowerPoint. I was a theoretical physicist, not an experimental physicist. So even my TV baffles me. I cannot cope with technology, and my colleague Imran Syed, who's on the next panel, will confirm that. I am on the Legal Resources Committee of the NIST, National Institutes of Standards and Technology, OSAC, Organization of Scientific Area Committees. So Glenn, who you just heard from, is on one of the OSAC, the sub-OSACs, subcommittee OSACs in the chemistry area, specifically the seized drugs. And so I want to step back and talk about what OSAC is. And let me ask, how many of you before today knew what NIST OSAC was? So a lot of people in the room didn't. And I suspect a lot of people who just raised their hands don't actually know what NIST OSAC does and what it's intended to do and what the ultimate outcome is. So I'm going to step back a little bit and talk a little bit about the big picture and then where the Legal Resources Committee fits in with that. So the NIST OSAC got going in the fall of 2014. The first meeting we had was in early 2015. And the idea of this whole project is you have all of those subcommittees. Glenn had a slide showing something that looked like an atom with a molecule, with little atoms coming off to the side. And those are the subcommittees. And the idea is that each of these technical subcommittees, like the one that Glenn is on, work to create standards or guidelines. Standards use the word shall. So you shall do this when you're performing this particular analysis, this particular test. Guidelines use should. You should do it this way unless there's a good reason not to. And the idea is that each of these will produce guidelines, and then these guidelines will go up to this system where there's a committee that sits over each subcommittee of other scientists in the same area. Then they're reviewed by the Legal Resources Committee, so that's a group of lawyers I'll talk about in a little bit. The Quality Infrastructure Committee, which basically makes sure the standards are written in the right format. And a Human Factors Committee, which is supposed to look for cognitive bias in how forensic science is performed. Then it goes to the top layer, the Forensic Science Standards Board. I think I said it backwards. A board that sits at the top, which is roughly analogous to the commission. That's the other parallel process. And then if it passes them, then it gets listed on something called a registry. So now there'll be a registry of standards and guidelines. And these standards and guidelines can then be used by forensic scientists to how do you do things right. But more importantly for us lawyers, these can be used in court. So when somebody gets on the stand and says, I did this analysis this way, they can be examined. Did you follow the standard that is on the National Institutes of Standards and Technology registry? Or did you deviate? Did you do things wrong, possibly on cross-examination will be the focus because you didn't follow the NIST standard for how to do these things. So that's the idea from the lawyer's point of view, is we want to get standards and guidelines that can be used in court to inform whether or not the forensic scientists who come in and testify are doing things the right way. Okay, that's the background. The Legal Resources Committee consists of 11 people. There's one other representative of an innocence organization, Barry Scheck from the Innocence Project. There's 3 prosecutors, 2 state and 1 federal prosecutor, 1 public defender. There are 2 representatives of forensic science organizations, including the counsel to the Texas Forensic Science Commission and a former counsel for a crime lab, 2 judges, and excuse me, and 1 pure academic, David Kay, who teaches evidence at Penn State. Many of us have backgrounds in science, as I do, and the rest of us have become very interested in forensic science and have developed expertise, often in very, very particular areas. For example, our public defender, Jennifer Friedman from Los Angeles, has become a real expert in DNA. So when we met for the first time in early 2015, we on the Legal Resources Committee came up with a list of things we really care about, what we really want to get out of this commission. And to quickly run through that list, first of all, Brady. We would like to see the standards and guidelines require the forensic scientists to list what they did, even if it doesn't favor the ultimate outcome. So if they ran a test and it didn't match, and then they ran it again and then got a match, the lawyer should know about the first test because that's potentially exculpatory material. Very often, the notes and original test runs in crime labs across the country are tossed. And so the defense lawyer will never know that it took 4 tries to get this result that the prosecutor is using in court. Secondly, we would like to see compliance with the Daubert standard, or in states that don't use the Daubert standard, Frye standard. And so in particular, we'd like to see some acknowledgement that there is an error rate and an attempt to calculate roughly what that error rate would be. We would like to see the standard and guidelines bar the use of ipsi-dixit, something that Daubert specifically talks about. Ipsi-dixit is when an expert comes in and says, it is this way because I know it to be this way. So I don't have to rely on those stinking scientific studies and results. Just trust me based on my awesome credentials and experience. It is this way. That's ipsi-dixit. And so we'd like to see standards and guidelines specifically bar the forensic scientists from coming in and talking about, I know it's true because I have all of this experience. And we'd like to see, of course, see the standards and guidelines reference solid research. And, of course, did the analyst apply it to this particular case? We'd also like to see the elimination of contextual information. In other words, as has been discussed earlier today, when the police officer comes in and says, here's the fingerprint, we think it matches this guy, will you please compare because this would really seal the case for us. That biases the outcome, so we'd like to see standards and guidelines. If at all possible, call for blinded testing or so-called sequential unmasking, where the analyst learns more and more as they need to know more, but does not know too much information that will bias their results at the very beginning. And we'd like to see the complete elimination of what we believe to be patently junk sciences, and bite mark is number 1 on the list. I know Chris will talk about bite marks, I believe. So those are some of the priorities that we in the Legal Resources Committee came up with pretty early. Frankly, I've been frustrated as a member of the LRC. Maybe the title of my little presentation should be, why are you still on this committee? And at the end, I'll have some notes of positive notes. First of all, we were told very early on by the FSSB, the Forensic Sciences Standards Board, the top level, that our role should be reactive, not proactive. We were all fired up to go out and be liaisons to all of these individual subcommittees and say, here are our concerns. Here's why we want you guys to be blinded to biasing information. Here's why we want to make sure that you list all of the bad results in your report before you got the match that you ended up testifying to and so forth. And we were told that the FSSB didn't see that as our role. They wanted us to be reactive to the standards that were being approved by the subcommittees and coming up. So they wanted us to comment on the standards instead of actually being active in the formation of the standards. One of the biggest frustrations, and this is getting into something that Glenn was just talking about, is the fact that most of the standards that we have seen so far have come from outside organizations. In other words, they're not being drafted by the subcommittees. The subcommittees are simply adopting standards that have been produced by outside standards developing organizations, so-called SDOs, ASTM being the most prominent of them. And the problem is that when we see then an ASTM standard that we have problems with, the FSSB says, well, all you can do is recommend that it be rejected or approved. You can't recommend that it be fixed because it's not their standard. It comes from an outside organization. And so with the standard that we just heard about, E2329, we did have very big problems with the line that in the absence of unforeseen error, an appropriate analytical scheme effectively results in no uncertainty in reported identifications. We had very big problems with that. We said that needs to be fixed. But we were told that it's take it or leave it because it's an ASTM standard. So that's a real problem. And this, it turns out, is now the very first standard that has made it onto the registry. So the very first standard uses the phrase no uncertainty, which seems to be sort of opposed to what the entire NAS project was all about. We've also met some resistance on other issues. Bite marks, I'll come back to that. A group of us on the Legal Resources Committee wanted to have the FSSB tell the Forensic Odontology Subcommittee that they cannot issue any standards or guidelines on how to do bite mark identifications until and unless there is actually some scientific validation for the project. And they basically told us, no, you can wait for them to produce standards and guidelines, and then you can complain about them, but we're not going to let you be proactive and tell us to tell them not to do that. That would still leave that subcommittee something to do, by the way, because one of the other things that forensic odontologists can do is match disaster victims, like plane crash victims, to dental records. There actually is science behind that one. So we've gotten a lot of pushback and resistance, and there's been a lot of disgruntlement on the Legal Resources Commission. So I'll close with, why am I still on it? Why haven't I quit yet? Because I've talked about it. In fact, I talked about it to Valina's class. I was a guest speaker to Valina's class via Skype a few weeks ago. Because our chair, Chris Plord, a judge from Imperial County, California, has encouraged those of us who are discouraged by the process that things will get better. And I'll point to a couple of things. First of all, he said that he has been told ASTM will amend the seized drug standard. And they will remove the offensive no uncertainty language. And they will remove that language from several other ASTM standards that are under consideration by various SACs. The problem is that ASTM is a slow process. Is it every 5 years? Yeah, it's a 5-year cycle. And this came out in 2014, so it's not up for 2019. But ASTM will consider doing it sooner than that. I also just heard from Chris that the forensic odontologists have finally agreed that they will not be issuing any standards or guidelines. So that's good. That makes me feel a little better that our complaints are being heard. And as for the one other complaint I should have mentioned earlier about ASTM, it's ASTM and the other standards developing organizations, they're not free. So these guidelines or standards that are going on to the National Institutes of Standard Technology Registry have to be purchased by members of the public. Now, it's progress that now they'll be free for 2 years for governmental organizations, but for members of the public, like private defense lawyer, they're not. And so why are we publishing standards and guidelines that members of the general public have to pay to get? And it's not just that you have to pay to get to standard, but for example, the seized drug standard that we've been talking about has references to about 8 other ASTM. So in other words, to fully understand what this means, because it says in multiple places, see something else, see another ASTM standard, you would have to go in and get them all. So even if this one becomes free, others are not necessarily going to be free. And so it is a problem that you have private organizations effectively controlling the standards process, particularly when you're told that you can't fix them. So with that negative note, you see, I go, it's kind of bipolar here. I'll go back and forth between it's all disaster and it's there's hope. I'll still end with, but there's still hope. Thank you.
Seeing the cursor here. What? All right, good afternoon. It's funny, I just want to say one thing about, because I was planning, like, as I was sitting in this audience today, I was deleting slide after slide after slide because everybody has talked about everything that I had planned to talk about. So what I've left with are some war stories to entertain you with, but which everybody wants to hear anyway. But one thing that related to the seized drug thing, and I'll preface it because I'm going to talk a little bit about this in the few words that I have left, that was really discouraging when I read the response to the Legal Resources Committee's critique of this standard that's now on the National Registry of Standards, the first one, and there are serious problems with it, is that the response from that OSAC committee, subcommittee, was pointing to its history of admissibility by courts as somehow validating this technique, and that was very, very frustrating, so I'll add that to Dave's negative comments. So flawed forensics in the status quo, where are we right now here today, is that we have scientifically literate judges, scientifically illiterate lawyers, and scientifically illiterate jurors. And these are the people that are charged with determining whether forensic science is valid and reliable science. This must stop because the result has been very plain. Wrongful convictions. Nearly half of all DNA exonerations have involved the use of unvalidated and unreliable forensic sciences. This is us, and I realized this morning also I'm wearing the same tie, but this is a different suit. And is Timothy Bridges. We announced this exoneration 2 days ago, and I was thinking about earlier another talk this morning about kind of unreliable convictions, and we in strategic litigation are not an exoneration part of what we do at the Innocence Project. We're a law reform project. And I took Mr. Bridges' case on, not necessarily to exonerate him, but because it relied so heavily on hair microscopy. And I thought it was an interesting case, too, because rather than an FBI agent who had come in and testified in his case, it was an agent who had been, or not an agent, but a state hair examiner from North Carolina who had been trained by the FBI to provide the same invalid testimony that the FBI has now admitted in thousands and thousands of cases. So Mr. Bridges' case is it's a repulsive case. The only evidence that was used to convict him were 2 strands of hair and 3 snitches. We found uncovered Brady evidence at some point that demonstrated that the police had coerced the informants to testify against our client, and it demonstrated just the strength and how these scientifically illiterate lay jurors will accept forensic testimony from an expert that's given the imprimatur of an expert by the court, of a scientist, and made it to overcome any doubts that they may or may not have had about the conviction. And Mr. Bridges, who was 22 years old when he went to prison for this, there was no internet when he went to prison. And now he's middle-aged. He's been in for 25 years. And he's trying to rebuild his life based on the strength of, or the weakness of one hair microscopist testimony. So yes, I have the dubious distinction of being an expert in bite mark analysis. I hope that it becomes an antiquated expertise soon. But as it is, I became first interested in this in that there's nobody in this room in terms of the scholars in this area whose work I haven't relied on in 1,000 different ways. And Professor Michael Reisinger pointed this initial case out to me when I was first getting involved in bite mark analysis because it's probably the worst offender of the flawed forensics that have been used to convict innocent people. And this is the original case. This is the germinal case in bite mark analysis. There's one earlier that was in cheese. This is the first one that was in human flesh. And so you go back, and I read the actual first case, and it was a case out of California. And what the first case found was that there was no science to bite mark analysis. There was no evidence that they'd done any experiments. There was no evidence that they had any number of a threshold number of points of concordance that needed to be made to declare an association. And the court swept all that aside and said, well, nevertheless, the Frye standard, I'm not even going to hold a Frye hearing because it doesn't apply. Because this type of evidence is so elemental, and it's so unlikely to mislead a jury, because it's just matching two things together, and I can see with my own eyes as a bench trial the conclusions that the experts are urging. And if I don't believe it, I'm free to reject it, right? So this is what opened the door in criminal courts to the use of bite mark analysis. So it was admissible as scientific evidence, although he said there was no science here. It was admissible as expert evidence in this particular case, but it wouldn't be required to undergo, in this case, Frye, I don't know if Kelly was out, Frye-Kelly standard in California. So the defendant was convicted, and this is a chart. This is from a law review article that Tucker Carrington and I have coming out pretty soon that kind of unpacks a lot of the jurisprudence around many of the failed forensics that have been used in wrongful conviction. And this is a chart that kind of demonstrates in Armstrong, you have the dubious distinction of the first court in the country to take judicial notice of the scientific reliability of bite marks analysis is in West Virginia. So I'm sorry. Perhaps you can do something about that. But the Marx case began, every one of these cases are cases of first impression except for the second California case, Sloan, that's up there above the dial line. Every one of these cases are cases of first impression in that state. And every one of these cases cited back to Marx for the proposition that the evidence is valid and reliable. And every one of these that's below the line, it's valid and reliable, and it's no need to even subject it to Frye scrutiny before its admission. It just relied simply on precedent to admit these techniques. And every one of these that are green admitted this testimony without a Frye hearing, without any scrutiny, and called it scientific evidence, citing to Marx, which found that there was no science in bite mark analysis. And there was never a single, and there still remains today, not a single negative admissibility hearing in any particular bite mark case that I'm aware of in the country, and I feel like I would know. And really sadly, as you see here on the bottom, if you see the Stinson case right there is at the end, that was a case of first impression in Wisconsin. And the Stinson case found that bite mark analysis removed the possibility of innocence of Mr. Stinson to a moral certainty. And Mr. Stinson was, in fact, innocent. He was exonerated. He spent 23 years in prison for a crime he didn't commit based on bite mark analysis. That's still good law today, the Stinson case. And worse, perhaps, is that State v. Stinson was cited by the Mississippi Supreme Court for the proposition that bite markers analysis was admissible in the LaVon Brooks case. LaVon Brooks was innocent. So it's the case law around this, and there's this reflexive embrace by courts of precedent, is that you have this, when you're litigating these issues, you have sometimes decades of precedent to overcome. And courts don't want to hold Frye hearings. They don't understand science. They want to have a battle it out, the crucible of cross-examination, which is a total fallacy because most defense lawyers are scientifically illiterate, and they're battling with somebody who has a real subjective belief in their own abilities. So what to do about this? This is from one of Simon Cole's articles, as I said, of always relying on Brandon Garrett and Simon Cole and Dave Moran and Keith Finley and all the luminaries and Jennifer Lauren that have been working in this area for a long time. But Simon had said, Professor Cole, had said previously, I think this was in 2008 maybe, that how courts will define the relevant scientific community and measure general acceptance when non-scientific experts offer testimony about what purports to be scientific evidence without any obvious scientific community to which a fact finder can refer for an assessment of the validity of this testimony. This is a serious problem, right? Because what you have in bite mark analysis, and I went back to that chart before, is that courts uniformly define the relevant scientific community as proponents of the technique. Right? So those who already generally accepted the technique were looked on to determine whether or not the technique was generally accepted. So you get these real problems, and we're here in this panel to talk about federal oversight. So what to do about this problem that Professor Cole identified is this is something that we in the Innocence Project have been advocating for recently, is that you need, and Ben brought this up too, is that you need to have a scientific community represented by NIST that's going to be able to develop an entity that will be responsibility for validating the validity and reliability of the OSAC structure, right? Because we see now standards are being pushed up that have not addressed any of the concerns of the NAS report of 2009, and they're just being kind of grandfathered in. So what this would do would give courts some guidance, right? And that body would be populated by scientists whose fields are necessarily implicated by the technique at issue, primarily statisticians, right? And cognitive bias experts, because statisticians have been missing from this process. Had a statistician been in the FBI crime lab 100 years ago and had read the testimony that those analysts were giving, making probabilistic statements or individualization statements regarding the probative value of a hair comparison, and they say, oh, we've known for a century you can't do that without population frequency databases. You can't say that. You just can't, right? Maybe you don't have the 75 wrongful convictions that are attributable to or hair comparison analysis if they just consulted with a statistician in the first instance. So federal oversight, we talked a little about the hair microscopy case audit. This is very, very troubling. And I've read a lot of these transcripts. And this is the findings that are agreed to by the FBI, is that they were making overstatements in virtually every case, right? And there was a lot of reasons for this. And I don't think that the FBI agents were deliberately framing innocent people, that they were dumb, that they didn't believe their own misleading testimony. But what happened is that in the overwhelming majority of these cases, there was overstatement. 9 of these cases were capital defendants who were executed before any review could be done of the scientific evidence that was used in their case. How could that be? How do we as a scientific community allow that to happen? And it's happening today in court, every day. There's a forensic analyst right now in court testifying to something that's scientifically unsupportable. We're seeing standards that are being pushed through OSACs, scientifically unsupportable. Bite mark experts are out there fighting for their right to come in and testify in cases, and we know what the result is. So this was the first a case that involved a full-blown evidentiary hearing in a hair microscopy case. This I litigated with Dana Delger and Lisa Kavanaugh from the Innocence Project or Innocence efforts in Boston, and with lawyers from Ropes and Gray. And this is the first one that went to a full-blown evidentiary hearing, and Mr. Peratt, as you can see, got relieved in this case very recently. I think that what was really significant about this was that we actually had an evidentiary hearing, and that these are the experts that were significant to the court's findings. And when the court came in, and we had Dr. Karen Cafeter came in and testified on our behalf, hair comparison experts from the FBI, and the head of the FBI's scientific analysis section, Dr. Mark LeBeau, came in and testified. And although the court denied our application to get a Teal Drawer to come in and testify about the cognitive science issues around hair comparison, what the court did was take a lot of the literature and made findings related to that. And the statistical evidence, and I think that this is really important as it relates to the FBI audit, because there are lots of rank-and-file scientists within the FBI crime lab who are resistant to this idea that there was anything wrong with the testimony that they were giving, and that there was anything wrong with the science of hair microscopy. And so it was very important to get a statistician to come in and educate the court, because there was going to be, despite this being a voluntary process and a collaborative process, experts that were going to come in and testify and resist the notion that there was something wrong. So Dr. Cafeter, the court drew significant conclusions from her testimony, and that mirror the NAS reports, but it went on beyond what the FBI was willing to concede around hair microscopy, because if you go to the FBI's website today, it states that the review, that the science of hair microscopy is not at issue, which is crazy. Of course it's at issue. I don't even understand that, but you go in and you have experts who will say that. And what that means, what the FBI means when they say that, is that the ability to draw an association between a crime scene hair and a suspect hair is not at issue, right? Just making the association. That's very misleading. Courts pick up on this idea that there's like, well, the science isn't an issue and that's not a big deal. But the truth is, the science ought to be at issue if that's what we're talking about. And Dr. Cafeter testimony proved this up, and the court adopted it, was that you have to have an objective threshold with clear indicators of what variables that you're observing in the known and the questioned hairs, and a number, basically. Talk about when it is that you can actually draw an association. Even the ability to draw an association, Max Houck did a study in 2002 that showed an 11% error rate on cases where FBI experts had declared a match, right? And so if you're litigating in these areas and you have a hair microscopy case, what you're going to have is courts that say, oh, well, it might have been a little bit exaggerated, but I'm still persuaded it's the defendant's hair. And what needs to be clear is that if you have an entirely subjective technique with no objective thresholds for declaring association, then you're going to get very significant cognitive bias issues. And what I think courts are now kind of slowly coming to the realization is that that matters. And it matters because in this particular case, what's really fascinating is that, well, one is that you get discovery and post-conviction. I was a trial lawyer for a long time, and discovery I would get like this, maybe I get an inch or two. And post-conviction, I get an accordion file full of files. So it's like, where was this at trial? I know it was just like, it's like, so we dig through that. And one of the things that we found was the prosecutor's notes on sentencing and before sentencing discussing the defendant. And he hated our guy. He just hated him. He just, and the really, really strange thing is that this expert had taken the serology evidence and the single hair that convicted George Peratt, personally drove it from Boston to Washington, D.C. crime lab. And our argument was that the personal animus that this prosecutor obviously had in this case must have been communicated to the expert and there was no requirement that a prosecutor not communicate to the expert today. Today there still isn't. And so the court found that and this is really an extraordinary finding, and if any of those want this opinion, I'll be happy to send it to you, is that the evidence established that in light of his enmity for Mr. Peratt, which is communicated to the expert, causing him to unconsciously depart from his role as a neutral expert and slip into the role of a partisan for the government. That's an extraordinary finding. I haven't seen this in any other criminal case that's reported, and it's so important as to not just the role that cognitive bias plays, but why subjectivity in the technique matters and why human factors matters in terms of blocking it. So this is my last slide. The retrospective reanalysis. I'm surprised that other people haven't talked about this, but when we talk about the statistical issues that are associated with bite marks or hair microscopy, and it was kind of described a little bit earlier, but the way that I tend to think about it is that there are two steps in this process. You're going to make an association, okay, there may be problems with that. But if you make one, so what's the probative value of that association, right? And if you don't have population frequencies, or there are some people that are promoting subjective likelihood ratios, which is a whole different problem. But if you don't have these, right, then almost anything you say in terms of pattern matching techniques is going to be overstated, right? Ballistics, shoe tread, tire treads, even fingerprint community is backing away from individualization claims. So Deputy Attorney General Sally Yates, who was mentioned a couple of times earlier, came to the AFS conference and said this and announced this retrospective reanalysis of all techniques in the FBI crime lab, where a testimonial overstatement was given. And those of you who have read the transcripts from prior convictions will tell you is that that's every case, right? Every case, right? So this is a massive undertaking, and we at the Innocence Project applaud them for their willingness to say what is scientifically accurate, what's true, and that we have an obligation, an ethical, legal, moral obligation. As science progresses, we have to look back. When we have a new standard, say, you know what, we were wrong, we can't do individualization, we have hundreds, maybe thousands of people in prison that are there based on what we know today is invalid testimony, and we have an obligation to correct the record. Thanks.
Turns out lunch is actually not going to be till 12:30, so we fortunately have a little more cushion of time. So now I'm guessing there are questions that the panelists have for each other.
actually know.
I'm good.
I don't.
I'll have one. So, Dave, regarding the legal resources kind of desire to have standards that can be used in court, I think you're absolutely right that what we're putting forward is not for that purpose. If you want something that's to be understood by the legal community, we have to rewrite it in language they can understand and point to all these primary references. And these documents that currently exist to tell crime labs how to do their thing, they don't have any of that. And it's not because it doesn't exist. It's because because they're the experts in their domain and they know it all. You know what I mean? They have degrees in the stuff. It's taught. You know, the same way that I don't know. It's innate. You know, I can only really talk about siege drugs here.
Well, I mean, the way the whole project was explained to us in Oklahoma City, which was the first meeting that we had, was that as to why we had a legal resources committee, why we had lawyers and judges on this committee, is that we were going to get a product that was going to be helpful to prosecutors and defense attorneys in court and judges who make Daubert and Frye determinations. And so the idea, that as we understood it, was that there would be these documents on the registry that the lawyers for both sides could look at and look at the experts testifying for the other side and say, are you following that? And if you're not following that, why aren't you following that? And judge, maybe you should exclude this testimony because this is a person who is not doing it the way that the certified good housekeeping seal of approval from the National Institute of Standards and Technology. So perhaps there's been a fundamental miscommunication between my committee and what was told to the other committees, but that was certainly what we thought we were there for, was to help shape these standards and guidelines so that we would have something that would be useful in court to help lawyers and judges decide whether they should hear from experts.
Well, I think there's still two totally different things. One is we are putting forward standards that tell crime labs how to do the science. And in terms of you saying, did you do this, then they can answer the question, yes, we did that, or no, we didn't do that. If the question is, what is this? That's a totally different question, and that's not what we're putting forward. Right? We're not helping you understand what it is. We're telling crime labs how to do it.
No, and that's right. And Glenn's right. I've reviewed scores of proposed guidelines and standards now, and most of them are so opaque to me, and I have a scientific training, that I can only imagine how opaque they are to people who have no scientific training. But it would be nice if the standards and guidelines, more than nice, it should be essential that the standards and guidelines have certain common elements in it. And these are the elements that are derived from Daubert, especially, that there is a recognition of an error rate, there's a citation to sources of the research that justify the standard and guideline. There's a prohibition on ipse dixit, as I talked about in my talk, and that and that the reporting include. There's almost all these standards and guidelines have reporting sections. What should be in the report? That the reporting be fair and full, so that both sides will know if earlier results weren't as tidy and pat as the final result is being presented. So I really see these standards and guidelines as having dual purpose, telling you folks how to do your job, but also having these things that make the resulting testimony more scientifically reliable, or at least alerting the lawyers and the judge when there's a problem.
Great. We'll take some questions from the audience.
Mr. Moran and Mr. Jackson, but I'm not quite sure. About a third of the wrongful convictions last year, according to the National Registry of Exonerations, a third of the exonerations last year, were drug possession cases in Harris County, Texas. And the reason why was because there's a head of the Conviction Integrity Unit there was taking a look at these cases, but it's because the drug field tests that are used have an extraordinarily high error rate. I think there's a study on one that found with Kitchen Botanicals in particular, one brand had a 70% false positive rate. Now in Harris County, you can get prosecuted for a felony for trace amounts of a drug, so it makes these tests particularly relevant there. So these people were getting they were told, well, this drug test came back positive, you're going to charge you the felony unless you plead guilty to this misdemeanor. A lot of pressure on people, particularly low-income people, to plead guilty to these, even if they're completely innocent, which is why we got all these exonerations. I personally have a kind of sort of a running list I've been tracking of things that have tested positive in these drug field test kits, and they range from chocolate chip cookies to Jolly Ranchers to soap, lavender, pool chalk. So my question is this being addressed? These tests are also used, for example, to establish connections in asset forfeiture cases, to take people's property. Is this something that the subcommittee on seized drugs is looking into? Thanks.
Please.
Absolutely. I should start with a disclaimer that I have some involvement with that case. I've taught a workshop last year at the Harrison County, actually not Harrison County, it was the Houston Crime Lab. And I also, a few weeks ago, was conversing with a lawyer, and I forget the name of he's an investigative lawyer with like an online publication, very reputable one. They've won several Pulitzer Prizes. Do you know it? Scott Hansen, there you go, Scott Hansen. All right, so I've actually seen some of the raw data from the crime lab that basically disputes some of the positive field test results by the cops. If you look at the SWIG drug standards, for example, the one standard that's on the National Registry, SWIG drug, so the ASTM standard, SWIG drug wrote a big document, they chopped it up and passed each one as ASTM standards, right? So there is a publicly available free, Bible of drug analyses called SWIG drug. You can get that for free, and all of it's been copied and pasted and turned into ASTM documents. So anyway, the one ASTM document that's on the National Registry says one test is not enough. You need 3. Right? Or at least, some combination of tests. And in fact, the one test that the field officers used was the worst discriminating power of any test you could use. And it would in no way pass muster. And so the one document that currently exists is one document that a lawyer could hold up and say, did you follow this? And the answer would be no, not at all. And so you can throw it out. Right? And as it's currently written, you could throw all that out.
There is a difference between using it as evidence in the courtroom, which is usually they wait for the lab results to come back, and using these field tests to make an arrest, to extract a plea bargain, to do an
Yeah. Well, yeah, but I mean, I'm a scientist and I can fix the science, but if you want me to fix the legal system, that's a different thing. I mean, I'm sorry you guys do that. I'm sorry you say this is not scientific and then you use it anyway. We can't help anymore.
I'm just one of the concerns that the Legal Resources Committee had about the standard, and Dave knows more about this than I do, and I'm not an expert in this area, but I think that there was some assertions that some of the tests were not correlated when it seemed that they probably were correlated. So that a macroscopic examination and a microscopic examination, for example, seem correlated to me. And then I think that if you use 3 tests and none of them are reliable, or maybe one's reliable and 2 of them are unreliable, then using 3 tests isn't necessarily going to make a better result.
Well, we're quite prescriptive about which tests you can't use any 3 tests. You have to use for example, at least one of the highest discriminating tests and then 2 others. And honestly, most labs go beyond the minimum requirements. And so you can't choose any 3. We're really quite prescriptive about how you should use them in combination.
For the scientists, my question is kind of what the lawyers were talking about, is that the legal concern seems to be we don't even know if this testing is valid to begin with. So before you go designing standards to say how to do it correctly, shouldn't we even consider if it can be done correctly at all? And so is that an accurate characterization? Within the scientific community, is there any concern or desire to sort of dig into the underlying foundation to say whether, this is even something that should be, or is it there just the assumption is that this works and we just have to prescribe the standards to do it correctly?
Well, this actually goes to that validity document we were talking about. And the slide that was up is really that validity document. There, in some, for example, I would agree with Dr. Jackson, GCMS is the platinum standard. So to dig into that makes no particular sense. I mean, the body of literature exists. So it's not that you'd have to start from scratch and go through that. But there are other ones where certainly that is. I mean, I think everybody in this room agrees that bite marks are awful. The scientists, the lawyers. And so there's gradations of that across the forensic practice. I mean, pattern matching, pattern evidence is somewhere in between. So in some cases, there would need to be additional scrutiny. And that's something, I mean, that's one reason that our subcommittee and the commission has drafted this document to try and address that and have somebody dig into it. I mean, scientists, by our nature, we want to dig into everything. And we never assume that something's right. I mean, imagine if you put when we do something, the first thing we do is throw it out to our peers and go through a meat grinder. I mean, their job is so the things that we are subject to criticism, we welcome criticism. Science naturally evolves and moves forward without looking back, by and large. I mean, it is a human endeavor, but so it's a different kind of culture. But there are some that, GCMS, it's well known, it's well characterized. It doesn't really need to be redone. The science behind DNA instrumentation is well understood, well done, but there are other aspects that do. So I think the scientific community always wants to always explore and always move forward. But the underlying validity, I think there are some areas where certainly that has to be examined, and that's one reason that our subcommittee has put this document forward. And I would urge you to read it. It's not long. Here's something I learned in the National Commission. Scientists and lawyers write differently. You guys are like footnote happy. And the first footnote I see, eyes glaze over, I'm done. So it's a different kind of, so that's a lot of the discussion is how do we write to make these things, but that's an aside. But take a look at those documents because there's a lot of those things coming out that talk about, because the problem is not unrecognized. So.
Some of the research that we do on hair analyses uses stable isotopes, which is a technique that's been used for 50 years in other disciplines, but it has only recently been used in forensic sciences. There was an article last year written by James Elleringer from the University of Utah in the Utah Law Review, and it's a very thorough review of isotope ratio mass spectrometry and its use in forensic casework. And so this document, it goes prescriptively through the Daubert standards and addresses each point within it. It points to the basis of the scientific of the method, how it can be applied, how it should be applied, and its context for use, the certainty that you have with certain results, and the testimony with it, and all and then precedent where it has been used in other disciplines, and it has a lot of footnotes and a lot of references, and it's written in a very friendly way. It's in a law review. And I think that's the perfect example of the type of document of what we could do, where scientists could write a document that shows you how that a discipline, a scientific discipline, is actually valid, right? And that's something that the legal community could use to say, look, here it is. Here are the primary resources, and here's all the justifications. The OSACs, we're not doing anything like that. We're telling crime labs how to do the science. And that law review article that I just described doesn't tell us a lab scientist how to do it. It tells the legal community about it. Does that make sense? And I think they're two totally different things. I don't think one document can serve both purposes, because the way you actually make the measurement and the way that you administer a lab to do it is very different from understanding what it is.
Even good science can be done very badly. And so I hear things like platinum standard, and in GC was specifically mentioned gas chromatography. In the Michigan Innocence Clinic, we have an exoneration of a man who served 27 years because a gas chromatography was done wrong. A peak, it is ultimately, a human has to look at a peak and say, what is that peak? And that human got it wrong. That human said it was gasoline, and when we had it reanalyzed 26 years later, it was not gasoline. We had it reanalyzed by much more qualified, much better analysts than who had done it back in 1986. It was not gasoline. And so that's why I think a clear majority of the people in the Legal Resources Committee need to say that it's not good enough to have standards and guidelines that simply say, here's the scientific cookbook, go. But we need to have the other information, such as what were you told before you declared that this peak on this gas chromatograph was gasoline? Because if there was biasing information, everyone should know about that. how many runs did you do before you got this, you reached this conclusion? And what happened when in those earlier runs? That information should be in the report. The report should be complete. And so there's a fundamental, and I think we're seeing it here, there's a fundamental schism in the OSAC about what needs to be in these standards and guidelines. Is it just the science, or is it the other things that can make the good science go bad?
I agree with that 100%. And one thing that I would say just about when you're not identifying sources of uncertainty and asserting effectively zero error rates, bringing that into a criminal justice system is essentially a directive verdict. There's, okay, then this person is guilty, right? And that's not accurate as a matter of science. I don't think there are any techniques or any scientists that would say that we never make a mistake. That's just not supportable.
Except I've seen that testimony this year.
Oh, me too.
I've seen 100% certain that this baby was shaken.
I've seen it with many times with bite marks analysis.
Yeah.
That man bit that person, right? It's to the exclusion of everybody else on the planet. Yeah. Accepted with great credulity by courts, lay jurors, and the rest. There are always sources of uncertainty. Right? You would agree with that, yes?
Yes.
Oh, yeah. Nobody would argue that.
Right.
But and to go back to, I hate to beat the dead horse, but to go back to the seized drug standard, the concern that we had in the Legal Resources Committee is not that the people on the subcommittee, the seized drug subcommittee, who are great, these are the top people in the country. We don't worry that they're going to go into court and say, I'm 100% right, there's no way I could have got this wrong because I'm relying on a standard that says there's no uncertainty. I'm worried about the people in the Detroit Police Crime Lab, which actually has now been shuttered. I'm worried about people in some other crime labs who will take shortcuts and then say, but according to the standard I'm relying on, there's no uncertainty because I did it right. That's why it's really important that there not be statements like no uncertainty in any of the standards or guidelines.
So just to clarify, the document does not say there's no uncertainty.
Essentially no uncertainty.
Right.
It says essentially,
Effectively
because
so.
the uncertainty is so small that we can't very well describe it, and we can't very well understand it. My colleagues and I, just this last week, were working on some probability estimates for just GC mass spec. This is one of 3 methods we will use. And depending on the database you use, the probability of a false positive we calculated was at least somewhere between 1,000,000 to 1 and infinity to 1 in terms of a positive result, with the likelihood ratio of a positive result actually having a positive drug in there. And that's one of 3 techniques we would use, right? So the others would have far less discriminating power, but you combine them because they're independent. And I don't know how you convey a probability that's so large that it's practically zero. Like it may.
But it's not zero.
It's not. It's absolutely not. That's the technique itself. But of course, there are always potential problems with the system, right? And with people making stuff up. And there are protocols to protect against that. And it's up to the administrators to enforce those protocols. And that's what ASCLD lab accreditation or ISO accreditation of the lab system is designed to do. But of course, there's humans involved, and that's where the errors
the problem.
are.
Yeah.
Yes.
So I just wanted to sort of jump into this as a member of the board of the Houston Forensic Science Center, which I guess you toured or visited, consulted with.
Yeah, last year I taught a workshop there
Right.
last year. Yeah.
Because we've, our defense bar, which is pretty assertive, they discovered that the analysts were running multiple tests in drug cases, and they became very concerned, outraged. They just keep testing and testing until they can find something, and there was a lot of concern. And my understanding from talking to the folks in the lab about this was that this was sort of standard protocols, and that's what I hear you saying, right? And they analogized it to like a doctor who might say, well, I'm not really sure, let's run this test, and if that doesn't turn out, we'll try this other test. Is that fair to say?
Yeah, because the different tests have different levels of discrimination, you run a quick and easy and cheap one and
Right.
see if it looks like it's going to be the, you
Right.
know, and if you test positive there, you're like, okay, well, let's put it on the more expensive instrument and spend more time doing it.
Yeah,
Right,
yeah.
and that one has higher discriminating power.
So I'm not sure that, like the takeaway for me was that running multiple tests is not a sign of some sort of bad thing that's going on that we
Gosh,
have
no,
to.
totally
right,
opposite.
exactly,
It's a sign
totally
of
the
strength.
opposite.
Yes.
But it is. I think you're right in that the defense bar needs all of the bench notes.
Right.
And so that's something that we're doing now in the lab was,
Or the prosecution, if it's a defense
it's like
expert. Yeah.
a major job, right? Because the volume of drugs is so overwhelming, and so there's so many tests, and the bench notes. It's not an easy task to get all the bench notes to the parties, but we're doing it now in the lab. But it's again, it goes back to a need for overall reform, and I think this is why Dr. Bell, what you were talking about, that there's a range, right? So you have DNA and drug testing on one end, and then bite marks, dog sense on the other, and then all the stuff in the middle. And it's kind of recognizing that there is this range, and figuring out the right testimony for each one. So it can't be the same sort of statement for all of these different things, because they're not equally reliable.
If I can interject, I have to tell a story. Last week, I was reviewing a proposed standard from the paint matching people. I don't forget which subcommittee that is.
Trace.
That's right, thank you. So the idea is to match a paint chip to a known source, typically a car.
Right.
And I'm reading along, and I had a lot of problems with this. I sent a lot of comments. But I got to one about if the unknown source does not match the known source when using this one particular test, do it over. Repeat the test. But not if they match.
Right.
And so you can imagine what I wrote about that. But that's an example of, in many of these standards and guidelines, that's the most extreme I've seen. There's a subtle cognitive bias of we should get a match, and there's something wrong if we're not getting a match.
Right.
But,
Yeah.
and I would add to that, though. I've been in forensic science for 30-some-odd years. I started in a crime lab, and I'm so glad that now there is an option for a level of review where somebody can raise that question. I mean, changing a culture is not easy, and it's not the scientific culture, it's not the legal culture, it's the whole culture. Right. And I guess that's why I remain optimistic. At least now those things get commented on, they get flagged and saying, whoa, let's think about that. So.
And I think you're right, and I think things like sequential unmasking, we're doing that in Houston now. So the kind of contamination of the prosecutor taking the evidence to the analyst, I mean, that's not going to happen in our lab, right? I mean, blind verifications, we're doing that now in 3 disciplines, and we're going to extend it to more. No one is doing that other than our lab, as far as I know. I think this is the future for forensic science, but it's part of a larger, sort of package of reforms that have to be done within the labs.
There's so much resistance to even the notion of cognitive bias in the forensic science community. I mean, many experts I've talked to reject out of hand that it could possibly affect them,
Right.
because they've had so much experience and that they know what they're doing and that they can shield themselves. And it's probably the most well-established social science research out there is like that you can't block yourself. It's humanly, you can't will it away. And you get that time and time again. In the George Peratt evidentiary hearing, the scientist from the FBI crime lab, who had been head of the hair and fiber unit and is now like the number 2 or 3 person in the lab, after we did about hours of cross-examination establishing that hair microscopy is entirely subjective, then denies that the more subjective a technique might be, the more susceptible it would be to cognitive bias. It's like, this is the head of the FBI crime lab.
Let's give our panelists a hand for a real fascinating panel. So lunch is served in the event hall, and be back here at 1:15 for the keynote address.
Dave says, correct. You guys are the cream of the crop people.